is Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of the Constitution. Our resolution tonight, timely following the inauguration, is does the federal government have broad implied powers? That might be a question many of us are already asking for the past few days. We are thrilled to host Georgetown's own on-law professor, among other things, John McCulloch, and Professor John Harrison of the University of Virginia to discuss this critical question. In addition, we are honored to have back with us again the returning champ, the esteemed Judge Anna Reyes, who has been kind enough to join us for a second event this year.
Hold on. He might have given you the misimpression that I was the first choice to moderate this event. I was not. I was the minor league player called up after the designated hitter went on injured reserve. So
we were just resting you for the best topic. And
yeah, sure.
We're deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster debate series a reality. I now recognize Ian Stapleton, our Director of Debates, to introduce these three stellar panelists. Thank you.
As Brady mentioned, we are excited to welcome back the Honorable Anna C. Reyes, who serves as a judge on the United States District Court for the District of Columbia. Judge Reyes was previously a litigation attorney at Williams & Connolly, where she spent her legal career from 2001 to 2023. While there, she served as the co-chair of the firm's International Disputes Practice Group and on its executive committee. Among her many awards, Judge Reyes was named as the Women's Bar Association of DC's Woman Lawyer of the Year. She received her JD, magna cum laude, from Harvard Law School, her MIPP with honors from the School of Advanced International Studies at Johns Hopkins University, and her BA summa cum laude from Transylvania University. Following law school, Judge Reyes served as a law clerk to Judge Amalia L. Kurtz on the Second Circuit. Our very own Professor John McCulloch is the Carroll Professor of Jurisprudence at Georgetown University Law Center. He teaches and writes on a variety of topics, including constitutional law, moral psychology, cognitive science, and human rights, among a host of other things. His recent scholarship has focused mainly on American constitutional history, including the original understanding of the preamble, the 10th Amendment, and the emoluments ex post facto and necessary and proper clauses. Professor McCulloch received his BA from Amherst College, a PhD in philosophy from Cornell University, and his JD from Stanford Law School. Before coming to Georgetown, he was a lecturer and research affiliate in the MIT Department of Brain and Cognitive Sciences, an associate at Simpson, Thatcher, and Bartlett, and a judicial clerk to Judge Rosemary Marquette on the 11th Circuit. Last but not least, as you can see on the screens on either side of me, we welcome Professor John C. Harrison, who is the James Madison Distinguished Professor of Law and the Class of 1941 Research Professor of Law at the University of Virginia School of Law. His teaching subjects include constitutional history, federal courts, remedies, corporations, civil procedure, legislation, and property. In 2008, he was on leave from the law school to serve as counselor on international law in the Office of Legal Advisor at the United States Department of State. The graduate of the University of Virginia, Professor Harrison earned his law degree at Yale Law School. He was also an associate at Patton Boggs and Blow in Washington, D.C., where he also clerked for Judge Robert Bork on the D.C. Circuit. He also worked the Department of Justice in numerous capacities, including as Deputy Assistant Attorney General in the Office of Legal Counsel. So without further ado, if we could welcome our amazing panelists again, I turn it over to Judge Anna Reyes.
Well, before we you forgot one of Professor Harrison's most important titles.
Oh?
Yes, yeah, he is the favorite professor of one of my current law clerks. I don't know how you didn't know that. So this is the Daniel Webster debate series. We're talking about federal implied powers today. Who can tell me how Daniel Webster plays a major role in federal implied powers?
Well, he was one of the attorneys that argued McCulloch v. Maryland in the Supreme Court.
Perfect. Yes. Thank you. Who are you?
Blake.
Blake. All right. Blake wins the contest for today. Your debate get-togethers will give you the prize after. Very well done. All right. So this debate should more properly be titled Hamilton the Musical, the Missing Cabinet Battle #3. The question on the table whether the Constitution grants the federal government the implied power to incorporate a national bank. Taking the floor first, Thomas Jefferson argues for the anti-federalist that the Constitution only grants Congress limited enumerated powers. Enacting a corporation, such as a bank, is not one of those enumerated powers. And because the enumerated powers, quote, can all be carried into execution without a bank is not necessary and consequently not authorized by the Constitution. Now, earlier, Jefferson had written to James Madison rejecting a proposal by Governor Henry Lee of Virginia to open a local bank in Virginia. Governor Lee wanted to do this to counteract the federal bank, but Jefferson did not want this because any move at all to acknowledge a central bank was, quote, treason. He wrote, quote, the power of erecting banks and corporations was not given to the general government. It remains with the state itself. For any person to recognize the U.S. Congress, which he termed a foreign legislature, in a case belonging to the state itself is an act of treason against the state. And whosoever shall do any act under color of authority of a foreign legislature, again, the U.S. Congress, whether by signing notes, issuing or passing them, acting as director, cashier, or in any other office relating to it, shall be adjudged guilty of high treason and suffer death accordingly by the judgment of the state courts. So as Ron Chernow put it and Alexander Hamilton, in other words, the principal author of the Declaration of Independence was recommending to the chief architect of the U.S. Constitution that any Virginia bank functionary who cooperated with Hamilton's bank should be found guilty of treason and executed. In his public comments, Jefferson argued that to read the word necessary to include the incorporation of a non-enumerated power, such as incorporating a national bank, quote, would reduce the whole Constitution to a single phrase, that of instituting a Congress with power to do whatever would be for the good of the United States. And as they would be the sole judges of the good and evil, it would also be a power to do whatever evil they please. Responding to the Federalist, he said, quote, it has been urged that a bank will greatly facilitate or convenience. It has been urged that a bank will grant facility or convenience in the collection of taxes. Even if true, he said, quote, the Constitution only allows the means which are necessary, not those which are merely convenient for effecting the enumerated powers. If such a latitude of construction be allowed to this phrase as to give any non-enumerated power, it would swallow up all of the delegated powers and reduce the whole to one power. Therefore, it was that the Constitution restrained the term necessary to mean, that is to say, to those means without which the grant of power would be a nugatory. President George Washington, somewhat concerned with these views that were expressed by a Secretary of State and similar views shared by his Attorney General, asked Alexander Hamilton, then the Secretary of Treasury, to provide a response. On a deadline, because George Washington had to sign on a deadline, Hamilton worked feverishly to respond, including pulling an all-nighter. For the record, his wife, Eliza Hamilton, stayed up with him all night, transcribing what he said. Confident that has not made its way into any of the articles on this. I hope at some point in the future, one of our esteemed professors will give her her due. Taking the floor for the Federalist, Hamilton threw some serious shade at Jefferson, arguing that the Secretary of State's argument contains, quote, a radical source of error in reasoning, end quote, and that his interpretation of the word necessary is, quote, so erroneous a conception of the meaning of the word that it should be exploded. And that's just him getting started. Hamilton told Washington that, of course, the federal government had the power to incorporate a bank, and Jefferson's interpretation of followed, quote, would be fatal to the just and indispensable authority of the United States. In italics, he wrote, the general principle of implied powers is inherent in the very definition of government and essential to every step of the progress to be made by that of the United States. Namely, that every power vested in a government is in its nature sovereign and includes, by force of the term, a right to employ all means requisite and fairly applicable to the attainment of the ends of justice. Hamilton highlighted that the view of the word necessary, quote, would be to depart from its obvious and popular sense and to give it a restrictive operation, an idea never before entertained. It would be to give it the same force as if the word absolutely or indispensably had been prefixed to it. One day after receiving Hamilton's response, President Washington signed the bill to create the national bank. The Supreme Court also ultimately agreed with Hamilton's take. holding in McCulloch v. Maryland in 1819 that the government did have the power to incorporate a national bank. Putting it rather mildly, Chief Justice John Marshall wrote in that case, quote, "The Constitution of our country in its most interesting and vital parts is to be considered. The conflicting powers of the government of the Union and of its members as marked in that Constitution are to be discussed, and an opinion given which may essentially influence the great operations of the government." He adopted Hamilton's view, which Daniel Webster had quoted to the court, that the word necessary did not mean indispensable as much as appropriate. Chief Justice Marshall predicted that, quote, "The question respecting the extent of the powers actually granted is perpetually arising and will probably continue to arise so long as our system shall exist." More than 200 years later, I think everyone in this room at a minimum can agree that Chief Marshall's prediction was right on point. And that is not an exaggeration to say that this cabinet battle addressing the powers granted to the federal government and those reserved to the states has been waged by opposing sides ever since, and has also been a main, if not the main driving force behind the development of our constitutional jurisprudence. And with that, I turn it over to Professor McCulloch. By the way, the professors have told me that they have a rap prepared. So you can go first with your version.
No rep from me. Thank you, Judge. It's an honor to be here this evening.
Oh, I forgot to say that. It's an honor to be here this evening.
That's the opening line of my rap. And it's a real pleasure to be doing this debate with my friend, Professor John Harrison. He and I have done a version of this conversation or debate in several venues. I always learn from him. I have great respect for him. And it's just a real privilege and honor to be doing this event with him and with you, Judge. So thank you. Well, I have about 7 minutes to kind of introduce my view on this topic. And I think what I'll do is actually try to pick up on where Judge Reyes brought us in terms of the debate over the First Bank of the United States. So one point that I make when I teach this material to my students in constitutional law is that it's important to put the debate over the First Bank of the United States in 1791 into context. So some of the relevant context includes the following. There had been a national bank of the United States prior to the First Bank of the United States. It was actually chartered under the Articles of Confederation about a decade earlier. And so the debate in 1791 is in some sense a rerun of a debate that had been held 10 years earlier under a charter of government that everyone agrees created a much weaker central government. So no one doubts that the government of the United States, such that it was under the Articles of Confederation, was much weaker than the government created by the Constitution. And nonetheless, by an overwhelming margin, I think the vote was 21-4 in that Continental Congress, or Confederation Congress as it's sometimes called, the bank was adopted. And at the time that the bank was adopted, arguments were made as to why that Congress had the power to charter the bank. And I want to call your attention to the fact that that was a much more difficult argument to make, because one of the provisions of the Articles of Confederation was Article 2, which was a reserved powers clause that was much more stringent than our 10th Amendment. And what it did, among other things, was reserve to the states all powers which were not expressly delegated to the United States in Congress assembled. That formula, reserving all powers not expressly delegated, is one of the reasons why the government under the Articles is considered to be a very decentralized, weak central government. It was a strong form of federalism that characterized the Articles. Nonetheless, the bank was adopted. When the Constitution of the United States was drafted and ratified, the framers had a choice. They could have put into the Constitution a similar provision, which would have reserved all powers not expressly delegated. And as John Marshall pointed out in McCulloch against Maryland, they deliberately chose not to do so. That's one piece of good evidence that the framers actually wanted a government with more implied power than had been available under the Articles of Confederation. The 10th Amendment and the language of the 10th Amendment was proposed and debated in the first Congress by James Madison. He drafted the first draft. He proposed it to the Congress. On 3 separate occasions, the argument was, or excuse me, a motion was made in the House of Representatives and in the Senate, twice in the House and once in the Senate, to add the word expressly to the language of the 10th Amendment, and it was rejected on all 3 occasions. It was voted down. The only recorded vote that we have is one in the House, and it was a vote of 32 to 17 is what I recall, so roughly 2 to 1. The Congress voted down the proposal to add the word expressly to the 10th Amendment, which would have narrowed the scope of the government's implied powers. This debate took place against the backdrop of the Constitution as it had been drafted, which critically had a necessary and proper clause. And the necessary and proper clause was drafted by James Wilson in the Committee of Detail. Wilson was actually one of the lawyers for the Bank of North America back in the early 1780s. And the other lawyer for the Bank of North America was Gouverneur Morris. So it's quite important to notice that the lawyers for the Bank of North America are the 2 principal draftsmen of the Constitution. It doesn't stand to reason that they, who had argued for Congress's implied power to charter a bank under the Articles, would have drafted a Constitution that gave the government less power. And they didn't do so. They drafted a Constitution that gave the government broad implied powers. And by a general understanding, I think, in the early years of the government, the major sources of those powers were the necessary and proper clause on the one hand and the preamble on the other. And Wilson and Morris were instrumental in putting into the Constitution the necessary and proper clause and the preamble. The supporters of the first bank in Congress made broader, far more far-reaching arguments than Hamilton made in his opinion on the bank that he wrote for George Washington. One point to really focus in on here is that if we're thinking about original public meaning as our touchstone for understanding the original Constitution, the opinions that cabinet officers like Jefferson, Randolph, and Hamilton wrote were not public. They were not intended to be made public. They were not made public. They were written for an audience of one, George Washington. And they weren't made public until 1805, when John Marshall wrote a biography of George Washington. That's when those opinions came to public light, and he paraphrased and quoted them to some extent. But what was public at the time in 1791 were the arguments of the supporters of the bank in Congress. Madison was a critic and an opponent. We're very familiar with his argument. This is a government limited in enumerated powers. We should hold the government strictly to its enumerated powers, and there's no enumerated power to charter a bank. The leading supporters of the bank in Congress, people like John Lawrence and Fisher Ames and Elbridge Gerry and Roger Sherman and others, made much more far-reaching, broad arguments for implied national power to charter a bank. And let me just paraphrase or describe for you the arguments they made. Basically, they were located in the necessary and proper clause and the preamble. Over and over again, members of Congress said, well, this government has the implied power to fulfill its purposes. We can identify the purposes because they're explicitly enumerated in the preamble, and Congress is given through the second necessary and proper clause, which expressly gives it the power to carry into effect all powers vested by the Constitution and the government of the United States and any officer or department thereof. The government of the United States, if it has the implied power to fulfill its purposes, together with the text of the necessary and proper clause, can give you a congressional power to fulfill those purposes. And that's basically what was argued over and over again. We're just talking about the bank at the moment. Let me broaden this still further. I think it's an easy question whether the first federal Congress had the power to charter a bank. I think that the implied powers of the government of the United States go much beyond that. And I've argued that in print on several occasions. So what are the implied powers vested by the Constitution and the government of the United States that are over and above the powers given to the president, Congress, or other departments or officers of the United States? Well, there's basically several categories of those powers, and I'll sort of mention some and list some and then turn things over to John. I think the categories are the following. They're the implied corporate powers that William Blackstone identified in his commentaries on the law of England. The United States government and the state governments, for that matter, were understood in the 18th century to be corporations. And
It
corporations,
might be today.
I think they are today, and corporations have implied powers that don't need to be enumerated. And the ones that Blackstone enumerated were the power to own property, to enter into contracts, the power to sue and be sued, power to operate under a common seal, and the power to enact bylaws. And all of those were powers that I think the government of the United States utilized right from the get-go in ways that we don't even pay attention to when we study constitutional law. The government of the United States entered into contracts. The premise that the government of the United States can sue or be sued is written right into the First Judiciary Act. It's not expressly listed, it's just a presupposition. And I could explain likewise for the other corporate powers. There are also implied national powers that the government of the United States possesses. And this generally leads us into the direction of Curtis Wright and the foreign affairs powers of the United States, for example. So let me just mention some of those. The government of the United States has the power to declare neutrality. That came up in the neutrality controversy. To engage in diplomacy, to control immigration. And of course, that's very relevant today, right? With what's
I hadn't heard
happening.
anything about that. Are there immigration issues going on?
I think they're gonna, coming soon to you, Judge. They're gonna be, before you, probably sooner rather than later. To regulate passports, to recognize foreign governments. The United States has the implied power to acquire and govern new territories. The Louisiana Purchase was the exercise of an implied power. To print money and make it a legal tender. That's the legal tender cases some decades later. To regulate Indian affairs. This comes up in the Brackeen case recently. I think there was a understood implied power that went beyond the Indian Commerce Clause into a general power to regulate Indian affairs. There's an implied power in the government to exercise eminent domain, and that has been recognized in the case law, and an implied power to fulfill the United States treaty obligations, which is relevant in Missouri against Holland. So I'll stop there. I could actually keep going. There are abundance of implied powers vested in the government of the United States that are not explicitly given to departments or officers, but Congress, I believe, has the power to carry them into execution through the necessary and proper clause. And I think this has been recognized in the case law in a variety of ways, but not always in the form that I've tried to present here today. So let me stop there.
Thank you. It's great to be here. Thank you, Judge. How is the audio?
We're getting a little bit of an echo, which makes you sound really super cool, but
Lovely.
maybe difficult to follow. Can you give us one moment? You guys have any idea what that might be?
Yeah, I think it's your phone.
Oh, can you put your phone somewhere separate from where you are?
How's this?
Still an echo.
Are you using your phone for audio or are you going through audio? to
Well,
your computer?
I am I had hoped not to use my phone for audio, but I've been having an audio problem.
Good. That's it.
Yeah, I mean.
I'm trying to turn off my phone's audio and use only the audio in the classroom.
Actually, Blake solved the issue. Blake is like the superstar of today.
Well, yes.
Blake, if you want to clerk, you just send me an application.
I'm happy to take you up on that at some point. Thank you.
My guess is that you would have clerked for somebody else, but you're welcome. Professor Harrison?
Yes? Okay. Well, we may.
Professor Harrison, you're free to go.
I'm trying to turn off the other audio. Can you hear me?
Yes, perfect now. Perfect. We can hear you just fine. Can you hear us?
I'm gonna guess you can't hear me. No.
No. We can hear you. I think he can't hear us now. If we're on mute, he can't hear us.
His phone muted. He was hearing on his phone.
I just want to say that the American Constitution Society, we would have figured this out. We may not have been able to execute it, but we would have figured it out. Can someone text him or email him or?
You have time to list more applied powers.
Oh, yeah, I can keep going, but that's sort of unfair.
He
gets his time. I wanna.
Maybe rather one-sided debate.
You might, if you can't hear in the classroom, you could also communicate with them through the chat.
Sorry, everybody. You all quickly, so. Mr. McCulloch, we have a federal implied power to fix the Zoom.
No, that's Congress's responsibility.
Well, that explains.
Okay.
Okay, can you hear us?
Yes, I can now.
What if he mutes his phone?
Can you mute your phone?
Well, when I muted my phone, I didn't get any audio at all.
Okay, well, why don't we try, the echo is less, so maybe just put the phone a little bit away from you. And then we can try, and then, I think it'd be great if you got started.
Okay, I just moved my phone. I
Okay,
have a feeling this is not, we've still got the echo.
Professor Harrison, could you turn off the classroom, your classroom link and just come in over your phone?
Well, I think the classroom link isn't on. Because when I turned off my phone, I got no audio either from me or from you here.
Do you want to just kick him off of this channel and just have him on his cell phone? I think that'll fix it. We'll just have the audio of the professor. Is he on there with his phone? Yeah.
Professor Harrison, can you hear us? I am feeling so smug right now. You have no idea.
On the Zoom?
Yeah, I messaged him.
Can you?
No.
Done anything fun since the last time you were here?
I was skiing over the weekend. A lot of fun. I was at Whistler.
Okay,
It was kind of fun. I was doing pretty well until I hit the peak, which is at the peak of the mountain, and I went down the saddle, which is a very, very steep black. And there hadn't been snow for a long time. So it's basically all ice, and I fell many, many times down it. And so I thought the obvious next step would be to try again. At which point, not only did I fall, one of my skis came off, so then I actually had to like tumble down the whole thing. But other than that, it was like great skiing. That was fun. Yeah, it was a lot of fun.
Any remaining injuries?
Well, I actually had a shoulder injury, but that was from a ski trip a year and a half ago. So
Geez, bad luck on the slopes.
I was hoping that if I knocked my shoulder in the right place, it would like uninjure it. Like I would just, but no,
What are you gonna be doing?
apparently it doesn't work that way. What have you guys been up to? What's been going on campus?
Try not to freeze.
Trying not to freeze. It was actually less cold where I was on the peak of the mountain than it was in DP. Yeah, it was actually quite warm. So. Yeah.
Antitrust.
What classes are you guys taking that are interesting?
Criminal justice with David Cole.
Oh, yeah, that's interesting.
Yeah.
Oh, yeah.
Yeah, we'll see.
Mergers and acquisitions.
No, it's very
Felix,
Felix. Well, Steve stays.
Yeah, so that was great.
Stays.
I'm in a really cool investor state dispute settlement seminar with
That's what I
Don.
do.
Yeah, with Don Wallace.
That's what I did, I guess.
You can do some in DDC, and so that's where a lot of. That's up, right?
There's a lot of challenges to arbitration awards that I've dealt with. Actually, my first case that went on appeal that got a decision was on enforcing an arbitration award.
Were you on the district court? Was it the next era
Oh, here,
case just
here.
last year, or was it the?
It was last year, it was
Spain.
oh, no, actually, more interesting. That was my case when I was at Williams and Conley. I represented Spain on that issue when I was at Williams and Conley. And
That's funny.
Folks, I think we might, if you guys want to just keep going, we're trying to get him, sorry for the trouble, but we're
Okay.
trying to get him to join through his phone, but so far, no luck.
all right,
He might be going to his office. and trying to read this.
do you want to just give him a couple minutes if he's going to his
I
office?
said, do you want to just start asking any questions you had for, we can just go to student one, let's do it forward.
Why don't we do that? Why don't you guys, because I don't want him to miss out on the debate. Like, do you guys have any questions for the professor or me about anything? Open mic?
So you list a host of implied powers that are historically grounded in either the common law or in the immediate historical context of the early colonial into the constitutional period. What does that mean though for modern implied powers? What is the contextual limit of how far those implied powers go? What is an example of overreach where they went beyond the implied powers that they had?
Right, so I think everybody understands that I'm giving an unconventional account of constitutional powers, right? I'm not giving you the orthodox doctrine. The orthodox doctrine is that this is a government of limited and enumerated powers, that Congress can only legislate if it is doing so pursuant to an enumerated power. There's a kind of a current understanding of the necessary and proper clause, which is far narrower than the one that I'm describing. What I was presenting to you is my understanding of the original Constitution. So how was the Constitution originally framed, ratified, and understood in the first years of the government?
I understand that's important these days.
That's the
When
thing.
we're-
So, right, so I think what we have is an inconsistency, a tension between the sort of received wisdom and the way we teach constitutional law and think about constitutional law, which is very enumerationist, to borrow a term from my colleague, friend David Schwartz, teaches at the University of Wisconsin. He coined that term to, I think, aptly capture our current jurisprudence on federal powers, which is deeply enumerationist, right? And this goes, for the president as well, and also, I suppose, for the Article 3 courts. Any act of any department or officer, if it's going to be constitutionally warranted, it has to be rooted in some bit of text. And the idea of implied powers is not utilized very often. John may be joining us, but I'm suggesting that there's an original understanding. The list I gave you doesn't just make itself known in the early period. Some of these are 20th century cases. Zivotofsky was a case that was about who has the power to recognize foreign governments. Ultimately, the court decided it was a constitutional power given to the president. I think that's the wrong way to think about it. I think the right way to think about it is it's a national power. It's a power that belongs to the government of the United States, unquestionably. Then there's a question of who in the government gets to exercise it. And the necessary and proper clause points by its very text to Congress at least having a role in carrying into execution that power. And that kind of argument, I think, can be made over and over again, whether it's legal tender, foreign affairs powers of a variety of sorts, immigration, right? So the Chinese exclusion case, I'm sure this is going to come up now quite a bit. Where is the source of all this power that the president is now exercising in these executive orders with respect to immigration, right? We know there's an enumerated power on naturalization, but what he's doing now is not only about naturalization, it's a variety of, well, the understanding is that the government has that power and Congress has something like plenary power over immigration. And I'm trying to explain why that's actually correct as a constitutional matter, even though the power isn't enumerated, because it was originally understood to be an implied power.
Would you say there are any modern examples or any examples of overreach then? Or
Sure. So I just want to make sure when John wants to join us, he can take over. But federalism and separation of powers and the Bill of Rights remain constraints on all of those. So you can't, the government can't just do whatever it wants. And there has to be kind of a historically rooted and jurisprudentially rooted argument for a particular implied power.
You have audio for me now?
Yes.
Yes.
Yeah.
Okay.
So yeah, there are limits for sure.
All right,
How is it? Is it as bad as last time?
it's perfect.
It's good. It's perfect.
Okay, so I went up to my office is what's going on here. So would you like me to start? Okay, good. The first thing I'll say about the interruption we just had is that it reminds me of a story involving not Daniel Webster, a great Supreme Court advocate, but somebody John McCulloch knows about, Luther Martin, who was an opponent of ratification. He was president of the Federal Convention. He ended up not liking what they'd done. He opposed ratification, became a leading Supreme Court advocate years later, and he was also a heavy drinker. And according to one story, at one point in an argument in the Supreme Court, John Marshall had to suspend the proceedings so that Luther Martin could sober up. I hope that's not the kind of interruption that we're talking about here, but I hope you can hear me now. Is what that comes to. Again, it's a pleasure. It's a pleasure to be here. Great to be talking again with John McCulloch. Judge, thank you for doing this. I want to say that I agree with John on a couple important things, but I disagree with him on a couple other important things. I agree that the necessary and proper clause, as we call it, has three components. What John calls the foregoing powers clause, the powers vested in the government of the United States clause, and the powers vested in other parts of officers and departments of the government. The direction that American constitutional law has mainly taken has been under the first part of the necessary and proper clause. The Congress has power to carry into execution the other powers given to Congress. A lot of the debate about the first Bank of the United States that we heard about a few minutes ago was about that. Congress can borrow money, Congress can spend money, Congress can have armies, and so forth. Can it create a bank in order to carry out those powers? That's a foregoing powers argument. I will say, I think that the foregoing powers argument in favor of the Bank of the United States is probably right, though it's not 100%, because the best reason to say Congress can create a bank under that part of the necessary and proper clauses is Congress is going to be is able to borrow money. One way to make it possible for people who have money who want to lend it to the United States to aggregate the money is to create a bank through which they can do that. So that's a standard foregoing powers clause, the argument, the kind of thing that James Madison considered and rejected. It was that line of reasoning that Alexander Hamilton embraced in his opinion in favor of the bank. Another big possibility that I think James Wilson agreed with, and I think John agrees with, is that, he said so, is that the Constitution implicitly vests a number of powers in the government. That vesting of powers in the government connects to the second necessary and proper clause, the one that says Congress can make laws to carry into execution powers vested in the government of the United States. I agree that Congress can do that. I agree that includes both explicitly vested and implicitly vested powers. The crucial point at which I disagree with John is in thinking that the Constitution doesn't implicitly vest in the government of the United States the power to act in the national interest, the power to act for the general welfare, the power to act to advance the interest of the United States generally. That, I think, is not there implicitly. I think it's also not there explicitly. The closest thing that the Constitution has to that that's explicit is the reference to the common defense general welfare in the power to tax, but on that, I agree with sort of the orthodox reading that that is commentary, that's an explanation of the power to tax. Congress can lay and collect taxes to pay the debts and provide for the common defense and general welfare of the United States. That's in the Constitution, but it's limited to explaining what the taxing power is for. Whereas I don't think that there is an implicit power to act in the national interest generally. I do agree with John that there is implicit power for the government of the United States to act for the United States as a corporate entity in both municipal law and in international law, from sovereign to sovereign, the kind of Curtis Wright thing that John was talking about. But domestically, implied power to act in the national interest, no, I don't think so. And the reason I don't think so is that I don't think it's there. Again, implicitly, it would have to be implicit. And I'll put it this way in terms I think connect to the way I believe James Wilson thought. He thought, I think, that the decision to have a national government that the people had made brought with it certain subsidiary powers, including the power to act for the national interest. That I don't agree with. That is a way power can implicitly be conferred. If you decide to do one thing, you're implicitly saying, yes, the means to the ends can be pursued. But that further decision was not implicit in the decision to have a national government, precisely because the scope domestically of the power of the national government was very much a matter of controversy in the 1780s and then into the early national period. Because it was a matter of controversy, somebody who said or acted on the principle we should have a national government was not thereby embracing this idea of having a national government that can act domestically in the national interest. Rather, somebody who wanted to convey that message would have said more, would not have left it implicit, would have explicitly said, and this new government will have that power. Because it was such a matter of debate and controversy, it was not built into just having a national government. The other thing I'll say, the last thing I'll say in this part is that what I just said, the federal government, the national government doesn't have a general implicit power, is consistent with the politics of the federal convention. The dominant bloc at the federal convention were people, individuals, and state delegations who wanted a much more powerful national government, wanted a proper national government with its own executive, with its own courts, and wanted it to be able to have its own taxing power, to be able to regulate commerce. They wanted limitations on the states. They were nationalists in those ways, much more nationalist than a lot of other people in the 1780s. They made a document that was so nationalistic it almost wasn't ratified. But they were, as I said, moderate nationalists. A decisive block of them saw risks in giving general power to the national government that might be used adversely to their own states, adversely to the interests they cared about, adversely to the public interest by people who got a majority in Congress and could engage in what we would call interest group legislation. So for those moderate nationalists, once they explicitly got the parts they really wanted, new powers in the national government, new restrictions on the states, the risk-reward trade-off changed. The value of getting a generalized power went down because they had the important things they needed, and the danger from a general power to act in the national interest went up because somebody could get a hold of it, somebody say like James Wilson, could get a hold of it and use it in ways that would be adverse to interests that they really cared about. I think at the federal convention, there were enough delegates and state delegations that thought that way. Enumerated power is good, implied general power dangerous, that we got what we have, which is a constitution for which the most you could say was, well, maybe it implies general power, but that's a not very strong argument. That's something I think James Wilson was able to get, but it was all he was able to get because the politics of the federal convention wouldn't support anything more.
So I have some questions. I want to put on the record that I've known about this for a week. I may not, I certainly don't have anywhere near the level of information that either of you two have. So I will try my best, but I want to start by picking up with where Professor Harrison left off, which is, I had previously read Alexander Hamilton by Ron Chernow, which was helpful in preparing for this. And apparently, when Hamilton was preparing his response to the Secretary of State and the Attorney General to give to Washington, he said that any review of the Constitutional Convention minutes would support everything he was saying, but he didn't want to cite any of it because he was afraid that if he cited parts of the convention, Madison would cite other parts of the convention to support his views. And so he left it to the secrecy of the proceedings. And at the same time, obviously, slavery was an issue in, I think, if not the background, the foreground of the convention. And I'm wondering, Professor Harrison, in response to what you just said, is if it wasn't so much that the moderate nationalists got what they wanted and then were scared of the implied powers, but it was more of, in order to get this done, in order to get this ratified, there needs to be enough ambiguity that we can argue for what we want later on, or we can write in the enumerated powers and then agree that there are implied powers in our understanding of the Constitution, but we're not going to enumerate all of them because then another bloc will be concerned that the government can address slavery. And if that was not a motivating factor for leaving in, or there were other motivating factors for leaving in ambiguity, and not so much that they were concerned about the implied powers. Does that question make sense?
Yes. And two things about that. First, it's certainly true that the danger to slavery of a general domestic power to act in the national interest concerned some delegates, concerned a lot of people in the South during the ratification process. And that's one of the reasons that some of the nationalists didn't want to go that far. But it's also true that even without regard to slavery specifically, some of the economic interests of the Southern states as exporters of agricultural products made them suspicious of a general national power that might be used in ways that would be adverse to their interests. The other thing I want to say about sort of the output of the convention and whether they were thinking we can leave something unsaid is that for a few of them, yes, but and Judge, tell me if I'm being responsive here. For a few of them, yes, but I think for a lot of those who wanted a new, more powerful national government, the reason that the Constitution doesn't go on more about, well, exactly what are the powers of the national government other than the ones that have been set out, as some were set out, is that nailing everything down in detail about exactly what powers Congress can exercise under the necessary and proper clause and what powers it couldn't would have prolonged the convention at a time when they wanted to come up with something. They would have had a hard time being even more specific than they'd already been. And so I think that the people I'm talking about, what I've called the moderate nationalists, thought they got the best deal about not giving Congress too much power that they could get without spending another 3 months in Philadelphia.
All right. So if do you want to respond to that?
Well, I was just going to say that I think you hit the nail on the head, Judge, by raising the slavery issue. So my view is that we really need to attend to the fact that the debate in Congress over slavery and the abolition petition, so this is rap battle number 3 for Hamilton.
They actually did
lovers.
do a slavery cabinet battle,
Yeah.
but they didn't include it in the final, and it's available in writing. I think because
And it's on the mixtape.
Yeah,
There's a
it's on-
second album.
thank you. Yes, it's
Yeah.
on the mixtape. I'm not a big fan of the mixtape, but
Okay.
I don't understand why Shiloh Sisters is not on the mixtape, but go ahead.
So So that occurred in 1790, and then the bank debate occurs in 1791. And in the 1790 abolition petition debate, there is certainly a block in that first Congress that is open to the idea that at least after 1808, Congress will have the implied power to pass a gradual abolition statute. I think that's the best reading of what happened there. The other thing I would just say is I basically agree with everything John said insofar as I think we're both saying there was a recognition inside the convention that some amount of ambiguity over the extent of implied federal power was going to be necessary to get the Constitution ratified. At least that's my view, and I think John would agree with that. The Constitution had to be ratified in an anti-slavery North and in a pro-slavery South. That's a crude way of putting it, but in states like Pennsylvania, James Wilson had to come out and say, this government will have the power to end slavery, and domestically. He even says that. It's hard, he's a little cryptic on that point. And meanwhile, people like Charles Cotesworth Pinckney and James Madison and others and James Iredell in the southern states have to say the exact opposite. Don't worry, this government will not have the power to act against slavery. And so knowing that, it stands to reason that the Constitution, the text of the Constitution, would have been drafted in a way that could lend itself to either of those readings. And I think the framers were astute and smart enough and focused enough on this issue to write a Constitution that had those alternative readings. It's a longer conversation where the real balance of power lay and what they all thought the future trajectory of the country was going to be. There's no question that eventually the federal consensus emerges, which holds that Congress has no such power to act against domestic slavery. But I have a hard time thinking that the delegates in Philadelphia wanted to hardwire into the Constitution in perpetuity a lack of power to act against slavery. I just don't think that's consistent with the evidence. So,
well, let me just ask you then, you said that Wilson and Morris, who drafted the Constitution in large part, were lawyers for the banks, and they wanted to have the power for the government to establish a bank in the Constitution. Why isn't that an enumerated power?
Well, they discussed this. The reason is the records suggest, Madison's notes suggest, that there was some sentiment in the convention that the banking factions or the banking communities in places like Boston and Philadelphia and New York would not take kindly to a red flag mention of a power over a bank because it was undermined the banks that they had already created. So in other words, it was a deliberate decision to omit enumerating a power over the bank that was based on politics and a sort of a sense of how, again, easy it's going to be to ratify, or are we going to put something in the Constitution that's going to raise opposition?
Well, then doesn't that tell us something about what the Constitution means? If they felt like they couldn't get the power, if they felt like they couldn't get the votes necessary to ratify the Constitution, if they had this as an enumerated power, I mean, I doubt what they would, I doubt Massachusetts, Philadelphia would be okay with being bamboozled. And, well, it's just an implied power, we just didn't tell you. Doesn't that tell us that the Constitution does have enumerated powers, does not have broad implied powers? And the reason we know that is because if those implied powers had been enumerated, it would not have been voted out. That makes sense.
That certainly makes sense. And I think it's a strong argument that needs a response. I mean, the bank is not the only example of this. So another example is the assumption of state debts. It was explicitly discussed at the convention.
Cabinet battle too.
Yep, and they, we're Hamilton's coming in a lot tonight. And they decided not to include that one in the Constitution, but the first Congress then went ahead and assumed state debts. And Virginia objected at the time, and a couple of the states objected. But again, it went through it actually went through with some difficulty, but they did it. So I think a generalization that we can draw, I mean, those are just two examples, is that there were a class of cases in which the framers and the Federalists who were going to run the first Congress expected to be able to do certain things, but they saw some political value in not enumerating them. Whether it would have resulted in the Constitution going down in Massachusetts or Pennsylvania, I think that is unclear. No one issue, I think, would have, there were too many issues in the Constitution that were teed up. But I do think there's evidence for some strategy that was engaged in, just like at the ratification conventions themselves. We can go back now and see, oh, there's some misleading representations or some shading of truth and so forth. The anti-federalists engaged in it, the federalists engaged in it, but that was just kind of ordinary politics.
All right, well, this is a question. The next one is for either of you or both of you. Alexander Hamilton, it turns out, was rather prescient in one of his key arguments to Washington. He wrote, quote, "It will not be doubted that if the United States should make a conquest of any territory, it would possess sovereign jurisdiction over the conquered territory. This would be rather a result from the whole mass of the powers of the government and from the nature of political society than a consequence of either of the powers specially enumerated." Why was this prescient? Anyone know? Blake?
Got nothing on this.
Because Thomas Jefferson, Secretary of State, had a rather different view than Thomas Jefferson, the President of the United States, when it came to the scope of federal power. When he bought Louisiana during the Louisiana Purchase, he made a determination not to seek a constitutional amendment to do so, but remarked that he only needed congressional approval. John Quincy Adams stated that the Louisiana Purchase was, quote, "an assumption of implied power greater in itself and more comprehensive in its consequences than all of the assumptions of implied powers in the years of Washington and the Adams administrations." And so my question is the scope of implied powers really in the eye of the beholder, or rather in the eye of the public office holder? Do an individual's views change depending on whether they are a state office holder or a federal office holder? Or are there other generally more entrenched views that office holders maintain irrespective of their vantage point? And the answer cannot be it depends. So either of you.
John, why don't you go first on that one?
Well, if it depends is not a good answer, how about yes and no?
Fair enough.
That is, I think for any individual, that individual's position on questions like this is going to have a part that is permanent, more or less, and a part that is influenced by the particulars of what office that person is in and what is the particular question going on. But so Jefferson was certainly somebody who was influenced by the particular question, and so sometimes was softer and sometimes less soft about enumerated powers. But I think there was something that was permanent about him, or Madison, or Hamilton, or all the people we know about, or James Wilson, Governor Morris, that they all sort of occupy different places around which then they vary depending on the particulars. But they're permanent. Jefferson was believed less in implied powers than James Wilson. I think we can say that, even though they're also influenced by their considerations having to do with the particular issue before them.
So what does that do to sort of an originalist position on the implied powers? Are we going to take the original position of look at what the founders said, but not what they did? I mean, isn't it fair to consider what Jefferson did while in office and considering his views as to what the Constitution actually meant?
It is, but it's also important to realize that political actors are always influenced by the specific question before them. And so in trying to figure out for the framers generally, or any particular framer, what that person thought, it's important to think about what that individual said on a whole range of issues and realize, okay, they're being pushed in one direction, they're being pushed in another direction, but they do have a center. And it's possible usually to identify the center and say, that's something that sort of you can look to historically.
Okay, fair enough. Professor?
Yeah, it's a great example. The Louisiana Purchase.
I love you.
Yeah.
I hit the nail on the head. That's
Well,
a great example.
No, I mean, I'm just stating truths here. So
Imagine if I had 2 weeks.
that would have been an easy question for James Wilson. In fact, already in 1785, before the Constitution was adopted, he said the United States has the power to acquire and govern territories, even under the Articles of Confederation. Jefferson's political platform in running for president in 1800 put him in a difficult position because it was a strict constructionist platform. He was on record on many occasions as saying the government could only act on the basis of its enumerated powers. So when the Louisiana Purchase opportunity arose, it was difficult for him. But if you kind of look, people around him, they were saying, of course you can do this and you should be able to do this. One example that I like, this is a little bit of cocktail party stuff, if you will. His attorney general was a man named Caesar Rodney Jr.
I want to stop you right there.
Oh,
If you are at a cocktail party and you're talking about the attorney general and the 17 whatever, it's like, you're not a good
those are the
guest.
parties I go to.
Okay, well, all right,
So-
you need better cocktails.
I don't know if I should go forward any longer. I feel very compromised. He was the son of the Caesar Rodney, who was a founder in the First Continental Congress, Second Continental Congress, and so forth. But he was also one of James Wilson's law students, interestingly. And he counseled Jefferson that the government did have the power to make the Louisiana Purchase. And I've always wondered whether the Wilsonian influence was there in the background. That's just one example. But I just think, and John Marshall, of course, ratified this later in the 1820s in a case called Cantor, I believe. So I don't think it's a hard question, this one. I think, of course, the United States as a sovereign nation has the power to do what any other nation could do in the international arena, and that includes acquiring territories. Now, whether Greenland and Canada should be part of that, I'll stop.
I do want to mention the treaty power is the primary explicitly enumerated power on which the acquisition of Louisiana by treaty with France could rest. Jefferson, to some extent, had backed himself into a corner due to political exigencies, I think, taking some positions mainly about with domestic issues in mind, that then suggested that he couldn't do things that the Constitution pretty clearly did contemplate, exercise the treaty power.
All right. Since we had a break, I think is it okay if we go over 705 by a bit? So another question for both of you. Are there any sort of upcoming Supreme Court cases or any issues that are percolating in the appellate courts, lowly district courts, that you all are looking for to assess sort of this question of implied powers that it might be implicated?
That's a great question. Immigration is very much on my mind today, as I think it is for many of us. It will be interesting to me whether the exercises of United States power over immigration through the agency of the presidency comes up as a kind of question of the allocation of power. So I think it's settled law that the United States has a power over immigration, but generally the thought is that Congress has the power to exercise over immigration, and the president's role, well, it's arguable. I mean, maybe under a certain interpretation of Curtis Wright, and is it a foreign affairs or an external looking power? Is it some other kind of power? It's interesting to me, for example, that the birthright citizenship issue can be looked at as a constitutional issue, but there's a statute that actually replicates the language of the citizenship clause in the 14th Amendment in Section 1. So there's a statutory statement about who may become a United States citizen, who is a United States citizen, and I think that
As a naturalized US citizen, that
Yep.
important to me.
And also those who are born in the United States and subject to its jurisdiction. So I think a really interesting question might arise about the extent to which, among other possible limitations on what the president is doing, there's something coming from the fact that there's a statute on point. So that's kind of an issue. It would be relevant to what we're talking about because, of course, Congress's power is an implied power, or it's an implied power. It's not expressly enumerated, but that's one that.
All right, Professor Harrison?
And question of congressional power that the lower courts have seen from time to time over the last 15, 20 years that I think is really interesting is what's the source and extent of Congress's power to regulate United States citizens' conduct outside the United States? Some of which has a commercial connection and so can be done probably under the foreign commerce power, but not all of which can be not all the regulation can be done that way. That extraterritorial regulation of a sovereign citizens is a classic instance of the exercise of a general power of sovereignty. It might come for the United States regulating Americans outside the United States. It might come from the Curtis-Wright part of implicit international sovereignty. But that's a question of actual practical importance, where these issues, exactly how should Congress's powers be understood? Where do they come from? Do they come from the enumeration? Are any of them implicit? If any of them is implicit, does something come from international sovereignty? Sort of the Curtis-Wright kind of question. That sometimes has practical implications. Regulation of American citizens outside the United States is one.
So can you give me a spoiler alert? If I get one of those cases, what am I supposed to do? All right, well, if I get one of those cases, what I will clearly do is appoint both of you as experts. So stay tuned if you get that request from me. I think we can go now to your finishing statements.
Okay.
So I'll let you start, and then Professor Harrison, I'll let you finish us off with the last word.
Thank you. Well, I'll just say that this has been a pleasure. I've really enjoyed the opportunity. I've done several events with John Harrison on this topic, as I mentioned, and I find it a topic that keeps on giving. So every time I come to one of these events, I'm finding myself wanting to say new things and hearing John say different things. And I think that's a testament to the richness of the topic. I will say that with some sense of gratification, that I think this topic is becoming more of a thing in the legal academy. I don't think it's yet made its presence in the courts quite so much, but I'm not alone in sort of doing work on the idea that there is much more implied power in the government than has traditionally been understood. So I'll mention some people. Jonathan Gannett, a historian, has written about this. Richard Primus at Michigan, David Schwartz at Wisconsin, and many others. So I think there's a kind of a growing group that is making these kinds of arguments. And I think people like John are very forcefully pointing out some, problems and limitations of the argument. So I see this as a really healthy dialectic, if you will, where we're getting closer to a better and better understanding of maybe what the original vision for the Constitution was, and maybe some ways in which our tradition has gone astray. So I kind of leave it there as on an optimistic, positive note. I find the entire conversation very constructive and very useful.
Thank you. Professor Harrison?
Well, like John, I find the conversation very instructive, very useful. And like him, I always learn something when we have one of these exchanges. The observation I'll make along those lines is that John McCulloch's scholarship, the scholarship he talked about, like John Gannapp's, is in large part the response to an intellectual movement that's to some extent associated with the Federalist Society. A renewed interest and a much more rigorous interest in originalism, in original meaning, in original understandings, generating more sophisticated arguments about what happened in the 1780s, 1790s. The fact that the level of argumentation, I think, is a lot higher than it was 30 years ago. And John and I can have conversations like this and get into real detail, get into serious questions about what was going on then and what that means for now. In part, that demonstrates sort of how important the intellectual movement that the Federalist Society has led in the last generation has been.
Okay. Federalist Society, great. All right. All right, thank you, everyone. I apologize. I have to run to catch a train, or else I would stick around. But thank you, everyone.